and thank you for joining Thompson Hine's weekly Coffee Chat series. My name is Ryan Wheeler. I'm an associate in Thompson Hine's Investment Management Practice Group. Today, we're fortunate enough to have Ed Redder, a partner in Thompson Hine's Employee Benefits Group. Today, we're going to examine the Department of Labor's recently updated parameters for determining when a person provides investment advice that triggers fiduciary status as outlined in the DOL's five-part test. We'll also explore how the DOL's interpretation of the five-part test has changed with respect to rollover recommendations and when investment professionals providing such recommendations become ERISA fiduciaries. Finally, we will discuss the availability of a new prohibited transaction exemption to address inherent conflicts of interest that arise when rollover recommendations rise to the level of investment advice. If you have any questions or comments during today's program, we encourage you to join the discussion by using the Q&A box in your control panel. We'll address your comments as we move through our discussion, and we'll try to leave some time at the end to answer these. We'll follow up accordingly to any questions that we don't get to during our time together today. Let's go ahead and get started. Ed, it's great to have you back on our Coffee Chat series. Before we get into the details, can you please provide a brief overview of the five-part test we referenced in the title of today's Coffee Chat for a frame of reference for those listening?
Yeah, thanks, Ryan, and thanks for the introduction. It's great to be with you today, and it's great to be with those in attendance today to discuss, I think, this very, very timely topic. Yeah, so as background, when we talk about this five-part investment advice rule, what we're referring to is a rule or regulation issued by the Department of Labor way back in 1975 that describes when someone is considered to be providing investment advice under ERISA. And that's critically important because when somebody is considered to be providing investment advice and receiving a fee for that advice, they're a fiduciary under ERISA, which brings with it all sorts of implications and consequences.
Got it. Thanks, Ed. Can you please explain why it's important to know whether a person is acting as a fiduciary with respect to ERISA plan assets?
Yeah, absolutely, Ryan. It's very important to know your status under ERISA and whether you're acting as a fiduciary. And as I mentioned, right, ERISA has a definition of fiduciary, and it's a functional test. And so regardless of the label you have, whether you call yourself an investment professional, whether you call yourself a consultant or otherwise, you're an ERISA fiduciary to the extent you provide investment advice for a fee. And so it's important to understand what that means. So under ERISA, we're subject to a number of very high standards of care and obligations under the statute. First of all, we have to act for the exclusive purpose of providing benefits and defraying reasonable plan expenses for plan participants and beneficiaries. So this is kind of where the duty of loyalty arises. We also have to meet the prudent expert standard under ERISA, which is, again, a very high standard of care. We have to diversify plan assets unless it's prudent not to do so. And we also have to follow the terms of the plan, again, unless they conflict with ERISA. Beyond that, we also have what are called prohibited transactions, and these are specific prohibitions that have been adopted to say you can't engage in this conduct, and if you do, there will be ramifications and penalties that arise. And so the structure of ERISA, though, paints with a very broad brush. The prohibitions are quite expansive. So for instance, one common prohibited transaction is engaging a service provider for a plan and paying that service provider compensation. And so you step back and scratch your head and say, well, how could that possibly be? All retirement plans have service providers. Well, so they paint with a very broad brush, but then they give back through what are called prohibited transaction exemptions. And, in that example that I just laid out, the common exemption that applied is under ERISA Section 408B2. And so it's engaging a service provider for necessary services for the plan when no more than reasonable compensation is paid for that service. And then a step above kind of the normal prohibited transactions that apply to what are called parties in interest, we also have additional prohibited transactions that apply to fiduciaries to plans. And those fiduciary prohibited transactions are really designed to get at and eliminate and prevent conflicts of interest and kind of split loyalties with fiduciaries. So those are kind of the general reasons why it's critically important to understand whether you're a fiduciary under ERISA or not.
Thank you. Yeah, speaking of the word fiduciary, that term is also referenced in the with respect to investment advisors under the Investment Advisors Act of 1940. Are the obligations consistent as applied between the SEC and the DOL?
Yeah, Ryan, that's a great question because, again, we have different types of investment professionals wearing different hats and subject to different regulatory schemes. And though a lot of these schemes use similar language, so yeah, it's important to step back for a minute. So we know advisors under the Advisors Act are subject to certain fiduciary standards, which are similar to, but not precisely the same as those under ERISA. We also know that the SEC issued Regulation Best Interest, which was kind of a step towards making the standard of care that applies to BDs when they're providing advice closer to that of advisors. And so we do have this kind of move closer among the three schemes, though I believe there are still significant differences. And I should step back and say, while I work with the investment management group often and collaborate often, I'm not an investment management attorney. But as I understand the fiduciary standards under the Advisors Act, one of the ways to address conflicts of interest is to provide disclosure. And if sufficient disclosure is provided, then we can kind of move on from that potential conflict. ERISA treats it differently, and the Department of Labor treats it differently, historically anyhow. Disclosure is oftentimes an element or a requirement of a prohibited transaction exemption, but generally is not sufficient in and of itself to exempt conduct under a prohibited transaction exemption. It's usually, again, one criteria or one requirement that has to be met, but certainly not sufficient on its own. So as a result, we do have kind of still some variation among the standards that apply to different professionals depending on the types of accounts or types of plans they're touching.
Very helpful. Thank you. Can you provide more details with respect to the five-part test, including a description of each of the five prongs?
Yeah, sure, Ryan. And so again, we're stepping back. This is based on the rule that's been in place since 1975, a year after ERISA was signed into law. So just very briefly to restate the five-part test. So a person is deemed to be providing investment advice under the five-part test if the person renders advice to the plan as to the value of securities or other property, or makes recommendations as to the advisability of investing in, purchasing, or selling securities or other property. It does so on a regular basis and pursuant to a mutual agreement that such services will serve as a primary basis for investment decisions and that such advice will be individualized to the investor's needs. And so, we have to step back and remember this was a test that was adopted way back in 1975. And if you think about kind of the evolution of retirement plans since 1975, there have been dramatic changes. We've shifted from a higher concentration of defined benefit plans where, the employer is choosing investments or an advisor for the employer is helping to choose investments. But that employer is still on the hook. They've kind of guaranteed a benefit when the person attains age 65 or normal retirement age. And so really the investment risk is on the employer. And now fast forward to now, and what do we see? We see defined benefit plans in decline. Fewer and fewer employers are sponsoring defined benefit plans. Many have been terminated. And now we have this explosion of 401k plans, individual account plans, where we have the participants who really bear bear the risk, right? They're oftentimes selecting the investments for their accounts and bear the risk rather than the employer bearing the risk. So we do have a change, but that's the 5-part test in a nutshell.
I know you kind of talked about the start and the beginning of the 5-part test, but can you give us a little bit more historical background, specifically how that 5-part test has evolved over time?
Yeah, absolutely, Ryan. Yeah, so again, as I just stated, originally adopted in 1975, in the 2000s, the Department of Labor started expressing some concern over the 5-part test, that maybe it's antiquated and doesn't really fit kind of the current environment for retirement plans. So there have been a number of proposals that have been made by the Department of Labor, many comments received by the Department of Labor on this issue, which ultimately culminated in the final fiduciary rule being issued in 2016. And so the final fiduciary rule actually heavily revised the 5-part test, kind of eliminated the 5-part test and revised it extensively, addressed the regular basis prong, addressed the primary basis prong, and certainly swept within its coverage recommendations on rollovers. But before the final fiduciary rule went into effect, as you all may recall who are listening on the phone, the courts vacated the rule in 2018, and so we essentially reverted back to the old rule. And then fast forward to last July, I believe it was July, when the proposed exemption that we'll discuss later came out. They also formally reinstated the 5-part test under ERISA. So we've kind of come full circle, and now we're back to the kind of 5-part test that we've lived with for a long time, at least on its face, right? And we'll get to how the Department of Labor has changed its interpretation.
Yeah, sure, and that brings up a good question. So if the old rule is essentially back in place, what has changed?
Yeah, so it's interesting how the Department of Labor addressed this, right? So instead of formally changing the rule or providing other formal guidance, what the Department of Labor did is in preambles, both in the proposed prohibited transaction exemption for financial institutions and also the final prohibited transaction exemption, they changed course on the interpretation of the 5-part test, primarily with respect to recommendations of rollovers. So, participant comes to you as an advisor or consultant, says, "Boy, what should I do? I have a large account balance in my employer's plan. I'm terminating employment. Got some options. I could take my account. I could leave it in the plan. I can roll it over to an IRA. I can roll it over to maybe my new employer plan. What should I do?" And so that's really where the Department of Labor weighed in pretty heavily and changed course, is on the recommendations of rollover advice.
Okay. I think that's important. Let's spend a little time on that. Specifically, what was the DOL's view before the recent change and how it recently changed its view?
Yeah, I mean, to sum it up quickly, and then we'll go into more detail, but the Department of Labor essentially did 180, right? They said, back in 2005, the department issued Advisory Opinion 2005-23A. And in that advisory opinion, the Department of Labor really answered a series of questions, but one was, is rollover advice given by someone who's not already a fiduciary considered investment advice? And the Department of Labor said no. If they're not already a fiduciary and they're providing advice on whether to roll out of a plan or not, that's not investment advice. And so, since 2005, we've had that interpretation. Now, again, I mentioned earlier that we had the final fiduciary rule, which altered that starting in 2016, but it never became truly effective, right? And so and it was vacated in 2018. So Advisory Opinion 2005-23A was essentially kind of sprung back to life and was the rule until this recent guidance was issued. And so again, in the preambles, we changed course on this. And essentially, the Department of Labor explained it that, they've had a change of heart. They believe that their 2005 interpretation was wrong, and that certainly advice regarding rollovers involve securities or property of a plan. And so they really jumped to the conclusion that, no, the first prong of the test that we discussed is satisfied when you're providing recommendations for rollover. Now, they stopped short of doing what they did in the final fiduciary rule, which was to say, yes, essentially, rollover advice is investment advice. And they said it is investment advice to the extent you meet the other 4 prongs of the 5-part test. And so let's dive into that a little bit because I think it's important. So again, we have to meet the other 4 prongs. One of the common kind of catch points for rollover advice being considered investment advice is whether it met the regular basis prong. And so you have to, again, advice has to be given on a regular basis in order for it to be investment advice. And so you step back to our earlier example of someone giving advice to a person for the first time on whether to stay in their employer plan or to roll to an IRA. Well, one could argue, well, it's the first time I gave advice. It's kind of one time only at this point. So how could it possibly meet the regular basis prong? And, there's some logical appeal to that. But what the Department of Labor said is no. Certainly if you have an ongoing relationship, so say in our example, the advisor had already worked with that individual, and now this is kind of just the latest iteration of advice being given, that certainly can meet the regular basis prong. But they went beyond that and said, even if it's the first advice the advisor is giving, if there's an expectation that if the person rolls over and that advisor will continue or on an ongoing basis provide advice to the individual regarding their account, then that's sufficient in and of itself. So it doesn't matter that it's the first time. It's the anticipation or expectation that it's going to be an ongoing relationship that gets you over the hump for the regular basis prong. So that's important. Now, the Department of Labor also stepped back and said, now, again, if it's an isolated event, right? If it's one-time advice, then no, you're not going to meet the regular basis test. Or let's say there's no expectation that you're going to provide advice in the future in that IRA, and the person happens to call you 2 years later and ask you for advice. Well, that's still sporadic enough. There's still not that expectation yet that it's going to be ongoing advice. So it's not a slam dunk that it's always going to be or satisfy the regular basis prong, but it certainly makes it easier and kind of broadens the scope of who could be swept within the coverage of the investment advice test. I would also say the Department of Labor also provided some thought on kind of the mutual agreement prong that the advice will serve as the primary basis and it's individualized. They kind of glossed over and said, yeah, boy, if you're having that engagement, if you're engaging with somebody directly, it's going to be awfully hard to argue that it's not individualized for that person's needs. And then on the mutual agreement prong, they say, one of the questions that has been posed is, hey, if we have disclaimer language in our contract and say, listen, there's no expectation, there's no mutual agreement among the parties that this is going to be investment advice, and so on and so forth, would that be sufficient to defeat the investment advice prong of there being a mutual agreement? And the Department of Labor said, yeah, that certainly would be evidence of the party's intent, but certainly not determinative. So if in the course of performance, in the course of your engagement, there's a clear understanding outside of the contract that there's a mutual agreement that individual is going to rely on your advice, then that'll overcome any disclaimer language. So we have to be cautious, to the extent an individual that's providing advice wants to stay outside of the investment advice realm, really their conduct has to match that language of the contract in order to do so. So sorry for the long-winded answer, Ryan, but I think those are the kind of the primary changes that were made in the guidance.
No, it's very interesting. So when did the DOL's change interpretation take place?
Yeah, it's interesting again because they talked about this because it was in the proposed preamble in the preambles to the proposed rule, and then also in the preambles to the final rule or the final exemption. The exemption actually went live on February 16th of 2021. There was some expectation, some chatter about boy, with the change in administrations in January, would there be some effort to at least delay the application of the rule or the effective date of the rule? And certainly, I'm sure there was some discussion, but ultimately, the Department of Labor let it go forward and go live. And so, I would also mention the Department of Labor just issued frequently asked questions last week, which also kind of go in a very digestible manner through the rules that we've just discussed today. And also talk about the prohibited transaction exemption, and it makes clear that yes, their interpretation applies currently, and so folks ought to be aware that that is out there currently.
And that brings up the question: is there any argument that the change in the interpretation could be applied to past interactions?
Yeah, it was certainly a concern of some commenters to the proposed rule that, okay, well, if this is just an interpretation, could the Department of Labor take the position that, well, they've been wrong all along and apply it to interactions that occurred before the final exemption became effective? And the Department of Labor cleared that up. They said, no, not going to go retroactive, right? But we will start applying it on February 16th. 2021. We're not going to give any kind of transition relief. This is a change in our interpretation, and so this is the rule going forward, effective February 16th, 2021. So yes, there was concern about it, but the Department of Labor addressed that concern, recognized that issue, and addressed it in the guidance.
Okay, that's very helpful and good news. Let's shift gears a little bit. Could you explain why rollover advice could be considered a prohibited transaction?
Yeah, it's kind of quirky, right? And so we have, a lot of the investment professionals I work with, right, are engaged by plans or by individuals, and you work through and you agree to provide certain services for a fee, whether it be a flat fee or a tiered fee or a percentage of plan assets. And really no issue. We have the reasonable contract exemption under 408B2. But this situation is a little different because now we have an investment professional that may be approached, or anyone else giving advice, I should say, being approached. They're engaging with an individual that has an account, either in an IRA or an ERISA covered plan, and being asked what I should do. What should I do? Should I leave it in the plan, or should I roll it over to an IRA? And so, if I give advice, and I'm not receiving any compensation at that point or receiving a fee, but if I give advice for them to roll over to the IRA, and I will be providing them ongoing services for a fee in that IRA, there's a conflict. I have an incentive, right? If I don't recommend the rollover to the IRA, I don't get the business. I don't receive any compensation. If I do make the recommendation to roll over to the IRA, I get paid, right? I'm going to receive compensation, even if it's reasonable compensation. But that distinction, right, that differentiation, the fact that I'm going to be paid if they follow my advice to roll over, creates a conflict of interest.
You touched on this a little bit earlier, but can you confirm, does this mean that an investment professional can never make a rollover recommendation without becoming an ERISA fiduciary and engaging in a prohibited transaction?
Yeah, it's a great question, Ryan, and I think it's important for people to kind of step back again. Remember, when we talked about, now this changed interpretation of the Department of Labor, it's still not automatic that rollover recommendations will be considered investment advice. We still have to meet the other prongs of the five-part test, including the regular basis prong, including the mutual agreement that it's going to be a primary basis for the decision and be individualized. So certainly there's still opportunity to fall outside investment advice, depending on the structure of the engagement and depending on the structure of the interaction. So for instance, if you truly are giving one-time advice, and recommendations on the rollover, and that's what you're being paid for, then yeah, it seems like you fall outside, right? You're giving one-time advice. It's not on a regular basis. No expectation that it will be on a regular basis, and so not investment advice. Similarly, let's say we have the disclaimer language, and it's very clear in the interactions between the two parties that we're not standing in that position. We're not seeking to provide investment advice, and that the individual shouldn't rely on our recommendations alone or as a primary basis for the decision. Also an argument that we fall outside of investment advice. And then finally, it's important to know too, even if you meet the 5-part test, the Department of Labor did issue a new prohibited transaction exemption. That's kind of where we got in the preambles the change in interpretation of the 5-part test. And so just very quickly on the exemption, you meet the exemption if the investment professional acknowledges its fiduciary status in writing, discloses its services and all material conflicts of interest, meets the impartial conduct standards, which are basically you meet a best interest standard, you receive no more than reasonable compensation, and you don't engage in any materially misleading statements to the investor. You adopt policies and procedures to ensure compliance with the impartial conduct standards and mitigate material conflicts. You document and disclose, and this is different because this exemption could apply to more than just rollover advice. But for rollover advice, you document and disclose why the rollover recommendation is in the investor's best interest, and you go through an annual retrospective review of the PTE requirements. And so, again, that's a mouthful, right? And we do have guidance, again, issued just last week in the as FAQs that I think I would recommend that people reach out to and look at, because again, it's a much more approachable read than sifting through the preambles.
Ed, must the investment professional comply with these standards now?
They certainly can, but way back in 2018, when the final fiduciary rule was vacated, the DOL issued an enforcement policy essentially saying, we're not going to enforce, we're not going to pursue claims for prohibited transactions by financial institutions and financial professionals if they're working diligently towards and in good faith meeting the impartial conduct standards that existed under the final fiduciary rule. And again, those impartial conduct standards are meeting the best interest standard, receiving no more than reasonable compensation for your services, and making no materially misleading statements to the investor. And that relief is still in place and will remain in place until December 20th of this year. So that is another opportunity or another option for institutions.
Great. All right, so the million-dollar question here. Is the DOL's final word on these topics?
No, it's not. And they made it very clear in the FAQs that they are revisiting all aspects of this. They are seeking comments, they're doing research, they're gathering information on whether there ought to be changes to the investment advice definition, whether there ought to be tweaks to the final exemption that just went live February 16th of this year, and also whether they ought to revisit and revise any existing exemptions. So I think it's safe to say, stay tuned. There certainly will be more to come.
Okay. Well, thank you very much. That concludes today's coffee chat. We do have a few questions. And just as a reminder, if you have any other questions or comments, please go ahead and enter them into the Q&A box. But Ed, I'll go ahead and ask you the questions that we have so far. The first one is, so if the advisor or broker-dealer goes back to compliance with the best interest contract exemption, will this comply with PTE 2020-02?
Well, I mean, if you're meeting the best interest contract exemption currently, you're subject to the non-enforcement policy that was issued by the Department of Labor, and so it seems that you're in good shape at least through December 20th, 2021. I would say I think there are some minor differences between the BICE or the best interest contract exemption and the current exemption, though my recollection is that the BICE actually had was a bit more restrictive or had more onerous obligations. And so I think what I would want to do is line up the two exemptions, see how you're satisfying the provisions of the BICE, and decide whether changes may be necessary. And so one significant difference I would point out between the two is in the BICE, right, we actually had to have a contractual provision, because the DOL's perspective back then was, hey, this is a good way to enforce it, right? So now we're going to have a warranty in the agreement that we're meeting this standard, and if there's a breach of that agreement, then the participant can sue for breach of contract. So while the fiduciary for the current exemption has to acknowledge fiduciary status, they don't have to. It's not a contractual provision, and so there's a difference. And there was a clear intent by the DOL to say, no, we're not creating some new private right of action as an enforcement mechanism. So there are differences, and I think it would be important to just take stock of what you have and compare it to the new rules requirements, even though they may change here in the future.
Okay. Thank you. We're getting close on time, so one more quick question, and then we can follow up any other questions we received after the program. So the second question is, what if you tell a client their options regarding a rollover, the pluses and the minuses, and then ask the client to decide, would this be ERISA advice even though you don't tell the client which way to go?
Yeah, it's interesting. You'd have to look at really everything that's said during that conversation, I think. I think there certainly is a possibility that what you're doing is providing education, right? That we're not making any recommendations. Here are the general pros and cons of being in the employer plan. So, for instance, generally employer plans have more significant assets than an IRA would have, and so the investment options are typically, they're better share classes, less expensive share classes, and so it oftentimes makes a lot of sense. You also have the fiduciary oversight of the plan administrator in the plan, and then in the IRA, there's broader selection and other benefits, and so I think you can make the argument, if you're just laying out kind of the general pros and cons of employer plan versus IRA, and then leaving it to them, not exploring their individual needs, but leaving it to them to make the decision, I think there's a strong argument that you're not providing investment advice. It's merely educational.
Okay. Very helpful, Ed. Thank you. So a couple closing remarks. Next week, we have a special edition of the Coffee Chat series being hosted on Thursday, April 29th. My colleagues, Richard Heller and Mark Miner, will be joined by Anthony Scaramucci to discuss the current state of private equity. To register for future Coffee Chat discussions, please visit the events page on the Thompson Hine website. To view any past Coffee Chat recordings, you can visit the Thompson Hine YouTube channel. Thank you all for your interest in attending today's program, and a special thank you to you, Ed, for sharing your insight. When the webinar ends, you'll be prompted to take a survey to provide feedback. Feedback is very important to us and will help us to continue to tailor our programs to your needs. Thanks again. Enjoy the rest of your day, and everyone stay well.